Welcome to the deep dive. Today, we're tackling a subject that is, well, inherently complex, emotionally charged, and incredibly high stakes. Navigating SNAP, the Supplemental Nutrition Assistance Program for families who have members with different immigration statuses. We've really stacked up the legal guidance, the government fact sheets, and policy analysis to execute one core mission for you: to extract the facts needed to separate the actual policy from the widespread fear out there. When food security is on the line, certainty really matters.
It absolutely does. And the sources show us that the rules are, well, they're highly detailed. Generally, only U.S. citizens and certain lawfully present non-citizens are eligible for SNAP. But when you have a mixed status household, say, a U.S. citizen child and a parent who is undocumented or maybe holds a temporary visa, the rules governing eligibility, confidentiality, and income calculation get really layered. We know that this confusion has a serious human cost. It contributes to historically low participation rates among eligible families, and, well, that's what we aim to clarify today.
Okay, let's unpack this then. Starting with maybe the source of the greatest confusion, the concept that can stop eligible families from even applying in the first place. What exactly is the public charge rule, and how does receiving SNAP fit into that whole equation?
Right. So the public charge determination, it's essentially a test used by immigration officials. They apply it when someone is seeking admission to the U.S. or applying for lawful permanent resident status, LPR status, green card. They're basically trying to figure out if the applicant is likely to rely primarily on the government for subsistence. And if the official determines yes, well, the application for status can be denied.
Okay.
But here's the critical fact, and it's highlighted in every single source we looked at. Receiving federal or state-funded SNAP benefits does not trigger a negative public charge determination. It is explicitly considered a safe benefit.
Wow, okay. That's a tremendous point to start with. So, applying for or receiving SNAP for an eligible family member, whether that's a citizen child or a qualified non-citizen adult, that doesn't jeopardize their path to permanent residency or citizenship, and it certainly doesn't lead to deportation.
That is absolutely correct. The legal guidance really emphasizes that recent clarifications of the public charge rule confirm SNAP is simply not one of the few benefit types considered. So this creates a critical legal firewall, if you will. Using a federal nutrition program like SNAP won't negatively impact an immigrant's status. It doesn't affect green card renewal or their future application for U.S. citizenship.
Excellent. That's a huge relief, I'm sure, for many listeners. Now that we've established the safety aspect, let's pivot to the complexity of eligibility itself. Who, besides U.S. citizens, is actually eligible to receive the benefits themselves?
Yeah, and we must be really clear here. Undocumented non-citizens are definitely not eligible for SNAP benefits. Eligibility is reserved for U.S. citizens and individuals the government classifies as qualified aliens. Now, this category includes lawful permanent residents, refugees, asylees, those granted withholding of deportation, and victims of severe forms of trafficking, among others. It's a defined list.
Okay, so qualified alien is the first hurdle.
Exactly. And once someone meets that qualified alien status, they typically have to meet one of several additional conditions. You can kind of think of these as falling into two main pathways: time or contribution.
Okay, interesting. What are those key conditions then? Let's maybe start with the time factor you mentioned.
Sure. The main time-based condition is the 5-year rule. A qualified alien must have lived in the U.S. in that specific qualified status for at least 5 years before they become eligible for SNAP. The good news here, and the sources clarify this, is that this residency doesn't have to be consecutive. So temporary absences of less than 6 months generally won't interrupt that 5-year clock.
Okay, 5 years in status. What about the contribution pathway?
Right. The contribution pathway is primarily for LPRs, the green card holders. They can qualify if they're credited with 40 qualifying work quarters. This usually works out to about 10 years of employment history. And what's particularly important here, I think, is that work quarters earned while that individual was undocumented. Those can, and often do, count toward those necessary 40 quarters.
Ah, that's a really crucial detail. So past employment, even if they didn't have legal status at the time, that still counts towards eligibility through contribution.
Exactly. It seems to speak to the intent of the program, rewarding contribution to the system regardless of prior documentation issues. And importantly, there are several groups who actually get to skip that 5-year waiting period altogether.
Oh, really? Which groups are immediately eligible then?
These are generally the most vulnerable populations, or those with military connections. So qualified alien children under 18 are immediately eligible, no waiting period. Individuals receiving disability-related assistance or benefits are also immediately eligible, and significantly, individuals on active military duty or honorably discharged veterans, along with their spouse or dependent children, they're eligible right away too.
Okay, that covers a lot of ground. So just to complete the eligibility picture, what if you're here on a temporary legal status, like say temporary protected status, TPS, or maybe a student visa? Are you generally excluded?
Precisely. Individuals with those kinds of temporary statuses, think H-1B, F-1 student visas, TPS, they're generally ineligible for SNAP benefits because they fall outside that statutory definition of a qualified alien.
Got it. Okay, here's where we move from the theory of eligibility to the really practical application. And this feels like the mechanism designed to counteract that fear we talked about. If a parent is ineligible, maybe because they're undocumented or they haven't met that 5-year qualified alien residency requirement yet, can they still apply for their eligible U.S. citizen child?
Absolutely. Yes. This is the core mechanism, really, that ensures eligible children, who obviously can't apply independently, can still receive food assistance. The ineligible adult applies on behalf of the eligible family members, and critically, they must designate themselves as a non-applicant on the application form.
A non-applicant, okay.
Right. So they essentially step into the role of the necessary informant for the household. The ineligible adult still has to provide all the household information, their income, any resources they have, expenses like rent or utilities, because that data is absolutely essential to accurately determining the child's level of need and the benefit amount they're actually due.
Okay, so the functional question then becomes, if the parent is listed as a non-applicant, is the state agency required to verify the parent's immigration status or social security number? Because, that verification step is what often creates the pathway for information sharing and the fear associated with it.
Right. And this is where that legal firewall we mentioned is really built. The sources are crystal clear on this. The state agency is explicitly barred from requiring or verifying the immigration status, or SSN, of the non-applicant household member. That parent is only providing financial data for the child's eligibility. They're not undergoing status verification themselves.
That legal protection seems clearly designed to counteract the fear factor. But what about that persistent concern we often see mentioned in community resources, the one about state agencies potentially sharing data with immigration enforcement, maybe with USCIS or ICE?
Yeah, that's a valid concern people have. The guidance, though, is pretty unequivocal on privacy. Application information for federal nutrition programs like SNAP is protected. States are generally not sharing this information for immigration enforcement purposes. However, there is a technical exception that needs a careful explanation. States are technically required to report unlawful presence to USCIS, but, and these are big buts, only when it's a formal, administratively reviewed finding supported by a specific determination from DHS or the Department of Justice. And critically, this reporting requirement applies only to individuals applying for benefits themselves. It does not apply to the non-applicants, like the parent applying for their child.
Okay, so the protection for the non-applicant parent is quite strong there.
Yes. The policy intention is clearly to ensure that eligible people, especially children, aren't dissuaded from applying just because of fear about the information they need to provide about their family situation.
Right. Let's transition now to maybe a more technical area, but one that can have big impacts. Financial complexity involving something called sponsor deeming. What happens if a qualified alien, maybe an LTR, has a financial sponsor?
Sponsor deeming, yes. It's pretty much exactly what it sounds like. A portion of the sponsor's income and their resources is legally deemed or counted as belonging to the sponsored LPR when you're calculating that LPR's SND eligibility and benefit amount. Now, this rule applies specifically to LPRs whose sponsor signed a legally binding affidavit of support. That's usually the I-864 Form on or after December 19, 1997.
Okay, why is that specific 1997 date so critical? What changed then?
That date marks the implementation of PRWAR, the Personal Responsibility and Work Opportunity Reconciliation Act, Big Welfare Reform Act. It significantly reformed welfare and really tightened the rules for sponsored immigrants. It made that affidavit of support legally enforceable and introduced these deeming rules, basically to hold sponsors more financially responsible for benefits used by the person they sponsored.
Okay, I can see how that would work. But if you add, a potentially high earner's income, the sponsor's income, to a low-income LPR's application, well, that LPR would almost certainly be disqualified based on income, right? Are there exemptions to this deeming rule?
Yes, absolutely. And there are vital carve-outs, really designed to protect vulnerable groups. First, all children under 18 are entirely exempt from sponsor deeming, full stop. Second, battered non-citizens are exempt for a 12-month period, and that can potentially be renewed if needed. And perhaps the most frequently used exemption is for indigent non-citizens.
Okay, how does the policy define indigent in this context?
So an LPR is considered indigent if their own income, combined with any cash or in-kind support they actually receive from the sponsor, is less than 130% of the federal poverty line for their household size. And crucially, the non-citizen can self-declare that the sponsor is not providing support. The state agency doesn't actually have to verify that lack of support to grant the indigent's determination.
Oh, interesting. So that self-declaration makes the exemption quite accessible for those who might have been, say, abandoned by their sponsor.
Exactly. If they're genuinely not getting support, they can say so. And that's generally enough for the indigent's exemption from deeming.
Okay, let's touch on the liability piece then. If the sponsored person does receive SNAP, maybe they qualify through an exemption, can the state actually sue the sponsor to recoup those benefit dollars? Is that a real practical threat people should worry about?
Okay, so technically the sponsor who signed that binding I-864 affidavit may be legally liable to reimburse the value of SNAP benefits received. The liability exists on paper. However, and this is the practical analysis from the sources, the state agency is generally not obligated to pursue reimbursement or file a lawsuit against the sponsor. While the liability is there legally, the complexity and the cost involved in actually pursuing it often mean that this rule serves more as a kind of deterrent than a frequently used enforcement tool for recovering, relatively small amounts of nutritional assistance.
Right, that provides really critical context. Technical liability versus practical enforcement reality. Okay, finally, for the listener who really wants to understand the nuts and bolts of the calculation, let's go back to that ineligible adult who is applying for an eligible child. We know they have to provide their income. How is that income actually treated in the final benefit calculation?
Right, the mechanics. The most common approach used by most states is called the pro rata share method. The goal here is, well, it's trying to be fair, but also somewhat conservative. So the ineligible member's income is divided proportionally among everyone in the household, both the eligible and the ineligible members. Then only the proportional share corresponding to the eligible members is actually counted as income against the household's benefit calculation.
Okay, let's run the math quickly using that guidance example you mentioned just to make it stick. Say we have a household of 4 people, 2 ineligible parents and 2 eligible U.S. citizen children, and the parents have a combined earned income of, say, $1,500 a month.
Right? Good example. So that $1,500 total income is divided by the 4 household members. That comes out to $375 per person. Now, since only the 2 children are eligible for the benefits, only their share, so 2 times $375, which is $750. Only that $750 portion of the parent's income is counted when determining the children's benefit allotment.
Okay, I see.
And this method typically allows the children to qualify for at least some level of assistance, even with the parent's income partially factored in.
That makes sense for income, it's prorated. But you mentioned resources earlier, things like bank accounts. What about the ineligible non-citizens' bank accounts or other assets? Are those also prorated?
Good question. No, they are not. And that's a really key distinction, and frankly, a major complexity in the calculation sometimes.
Whoa.
While the income is prorated, all of the ineligible non-citizens' countable resources, things like cash, bank accounts over the limit, maybe vehicles above certain limits, those are fully countable for SNAP purposes.
I see. So even if their income is only partially counted, the parents still need to have low resources overall for the children to be eligible.
That's correct. The resource limits still apply quite strictly to the ineligible members whose resources are counted for the eligible members.
Okay, wow. This has been an incredibly thorough deep dive into a set of rules that, yeah, they're complex, but they seem clearly designed to balance 2 key things: federal financial responsibility on one hand, and the protection of eligible children on the other. I think the core takeaway for everyone listening has to be that SNAP benefits themselves are safe from a public charge perspective, and that non-applicant status creates a vital legal pathway to ensure children can get food assistance without compromising the parents' immigration situation.
Exactly. And if you are taking notes, just remember that knowledge really is the key to participation here. Historically, as we said, fear and confusion have genuinely prevented people from applying. The sources showed participation for eligible non-citizens and their citizen children was hovering around, 55%? That's far below the national average for all eligible children. Understanding these specific rules, the ones we've talked through, that's really what closes that gap.
Indeed. But let me leave you, our listener, with one final thought, something maybe to mull over. Given that the ineligible parent's earned income is generally counted on that pro rata basis, which, in effect, makes the household appear less needy than if only the eligible children's zero income existed, what implications does this very specific rule have? What implications for maybe the long-term financial viability or the structure of food assistance programs that often rely on maximum efficient participation for their full effectiveness? We've covered the mechanics today. Now maybe consider the broader implications. Until next time, keep digging into the details.